Good afternoon.
Good afternoon.
So I'll run through the welcome and introductions, Andrew, and we're live and hoping Simon Butler will join us any minute, but we'll kick off because I'm conscious we've got an audience waiting to listen to your answers. So welcome to LAW2020 Online, Personal Injury Shaped the Debate with me, Emma Dion from the Solicitors Group, Simon Butler, who will be joining shortly, and Andrew McLoughlin. In this live session, you can put your questions to Simon and Andrew and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover pre-submitted questions and live questions put to us as the session goes on. To the right-hand side, there's a chat function. All questions are submitted in private, so please do ask away. It's anonymous, and yeah, do get your question in. If you're watching a replay, the live chat function is disabled, but you may contact the Solicitors Group for further information. A recording of today's live session will be sent out by email within 48 hours, so please do keep an eye out for this. I'll introduce you, Andrew, first, and then come back to Simon. So Andrew's been a solicitor in private practice since 1983, dealing with litigation in all its forms over those decades. In addition to his role as a regular nationwide trainer in litigation for the past 20 years, he also sits as a recorder in the Crown and County Court and is a part-time tribunal judge in the Immigration and Asylum Chamber. He was appointed as a court examiner by the Lord Chancellor in 2017. And as part of LAW2020 Online, Andrew's sessions included vicarious liability and fundamental dishonesty. I'll do Simon's introduction for when he does join the call. So Simon Butler. Simon is a senior barrister at 9 Gough Chambers, London. He's a common law practitioner and has appeared in numerous leading cases. Simon is popular with solicitors for his problem-solving, leadership, creativity and insight. He's respected by the judiciary and colleagues and has a thriving practice in England and Wales. And he's an engaging advocate and believes no stone should be left unturned. So we'll start with the pre-submitted questions. So the first one for you, Andrew, that's lucky.
It is, isn't it? Yeah.
Is on vicarious liability. Is it easier or more difficult to establish vicarious liability after the decisions in the Barclays Bank and Morrison's cases in the Supreme Court?
Okay, well, thank you for the question, Emma. I'll deal with it really in two parts. First of all, if we look at the Barclays case, the Barclays case was really the Supreme Court looking at the distinction between independent contractors and also the employees who were analogous to being a proper employee. So Barclays really was addressing that specifically. What they said was that factually in the Barclays case, the doctor who'd carried out these medical examinations was, to their eyes, an obvious independent contractor for a number of reasons. So they didn't have to address the specific point about what to do in doubtful cases. In other words, where a court would be unsure as to whether the person who perpetrated the tort was either a person who was in a position analogous to employment or an independent contractor. In those doubtful cases, and those doubtful cases alone, said the Supreme Court, then the 5 policy principles would only then come into play. Now, in essence, therefore, what does that mean? It means that the Supreme Court in Barclays have really made it a tad more difficult to establish liability if you're acting for a claimant, because for these reasons, really, the 5 policy principles, those had been enunciated by Lord Phillips in an earlier Supreme Court case involving Christian brothers, which involved physical and sexual abuse by a number of Christian brothers in the context of a school. And he set out these 5 policy principles, which in essence make it fair, just and reasonable to impose vicarious liability. Now, those 5 policy reasons, we probably don't have time to go through each and every one, but a key component of one of the policy out of the 5 was that the employer was likely to have more resources and means to compensate. So you could perhaps see where those policy reasons were going. They favour claimants. So really Lord Phillips was saying, well, if push comes to shove, the policy principles will make the employer liable for the acts of the employee or those akin to an employee. What the Supreme Court has said is, well, actually, those 5 policy features that favour claimants only come into play if it's a doubtful case, i.e. between an independent contractor status and akin to employment. So, as I say, a tad more difficult as a result of Barclays. So the second part of the answer, we now look at the Morrison's case. And what I'm going to say on this, again, as a headline to the answer, and I'll develop the reasoning, is that, again, it's going to be a little more difficult for claimants to get home as a result of the Morrison's case involving the various claimants. The Supreme Court, in the latest decision, Lady Hale, said that motive was relevant. And if you remember from the webinar about vicarious liability, the motive behind the IT auditor doing what he did was basically, they said, a personal vendetta. The backdrop was that this IT auditor had a poor review and basically got it in for Morrison's because he didn't think he was being treated fairly. That's got to be contrasted with the earlier Morrison's case called Muhammad versus Morrison, and again referenced on the webinar, namely that Mr. Khan, who was the employee who assaulted Mr. Muhammad, his motive seemed to be racially aggravated, as it were. He was assaulting Mr. Muhammad, as best we can interpret, because he was a black Somali, and he followed him out into the petrol kiosk. Lord Toulson, who gave the lead judgment in Muhammad, actually, by the time that the other Morrison's case had been decided, was dead. He died in 2017. So he wasn't really in a position to answer the reinterpretation of his words, because he sadly passed away. So again, the new Morrison's case is really focusing on, firstly, the field of activities of a particular employee. And here, remember, there's no dispute in the Morrison's case that the IT auditor was a proper employee. What the new Morrison's case is dealing with is there a sufficient connection? And there's 2 parts to that. And this is where you'd have to risk assess now going forward. You really have to drill into the details of what the field of activities of the employee are. The Supreme Court in 2020 specifically reference that. And then, having determined what those field of activities are, is there a sufficient connection between the employee's acts that are being complained of and what the employee should have been doing at the time? Now, in the new Morrison's case, the Supreme Court came out against vicarious liability on the basis that they didn't feel, on the facts, that there was a sufficient connection, but I say interestingly said that motive was relevant when they looked at what this guy had done. He'd gone home with a USB stick, downloaded information onto his own computer, then uploaded it to a file sharing site. The Supreme Court specifically said that uploading of information publicly, as it were, was outside his field of activity. He was only meant to, as it were, be accountable internally to Morrison's. So, again, the new Morrison's case, a little more difficult to establish liability because the Supreme Court have given, as it were, a green light to looking at motive, whereas hitherto Lord Toulson at least had said. I mean, it is a difficult area to look at, and I'm just looking now in terms of the practical approaches to this. It'll be difficult for both claimants but also defendants and defendants' insurers. So there may well be room for compromise in the fact-sensitive cases that you have. So, as I say, a long answer, but quite a lot of issues raised by the question. Thank you, Emma.
Yeah, thank you. Well, we temporarily had Simon join us in the room, but we can't see him yet. But I'll carry on with the next question then, if I may, Andrew, and hopefully Simon can hear us and we can see him shortly. So the next question that was pre-submitted: why are the acts of physical or sexual abusers still capable of being attributable to their employers, and thereby making them vicariously liable for those acts?
Thank you for that. And the answer to this goes back to the second stage of the test in vicarious liability. Is there a sufficient connection? That's the test. And that is between the position in which the employee was employed when the acts complained of occurred, when the acts said to be done have been perpetrated by the employee, whilst they're acting in the course of their employment. So there's been no change from the two recent Supreme Court decisions. So if you the Court of Appeal and the Supreme Court, both before and after Morrison's and Barclays, have looked at a few sex abuse, physical abuse cases in the realms of vicarious liability, and I'm going to say there's no change there. Lister versus Hesley Hall, which was a 2001 House of Lords case, that was a sexual abuse carried out by in a residential home by wardens, and that was sufficiently closely connected. And so I see no change in those, providing, and this is the caveat to it, providing the field of activities are sufficiently closely connected to what the acts complained of are. And as I say, if someone spies an opportunity to do something, such as abuse someone in a residential setting, that is probably going to be enough. So, thank you.
Okay, thank you, Andrew. Simon, can you hear us? Hopefully you can hear us. Simon, at the bottom left of your screen, you should the image with you in the centre. You should have a blue camera. A camera icon and a sound icon. If you could click on those, then they should turn to blue, and we should be able to see you and hear you. I can hear some clicking. Keeping everything crossed, folks. Bottom left. Camera icon and sound sound icon. Microphone, that's the word I'm looking for. Not quite there yet. I'm going to carry on with you, Andrew, while we try and sort out these technical difficulties. Sorry, you're in the hot seat this afternoon, aren't you? What advice would you give to a client when you feel that there may be a real risk of a finding of fundamental dishonesty and that the client wants to continue with the claim?
Sure. I mean, I'm perhaps sure any number of our audience may have come across this and this suspicion of that there's a risk that this may happen. And really what I do is boil it down to a few points. First of all, they've got to be advised and confirmed in writing about the risk of adverse cost consequences. If on the balance of probabilities the claimant is found to be fundamentally dishonest, as night follows day, they're going to get an award of indemnity costs against them. Now, that obviously, I say obviously, means that there would be no proportionality with regard to those costs, so that they would be liable for really the full whack. So if you're in a fixed recoverable cost regime, by way of example, a fast track, ELP, LRTA that's gone to a trial, you're not looking at fixed costs anymore. It would be, as it were, significantly greater than that. And I think that needs explaining to them. Second point, of course, is enforcement. Some clients may think, oh, well, I've got nothing. I live in rented accommodation. There's nothing to take. I've no savings, so I'll just give it a roll. And regrettably sitting, I've sometimes come to the conclusion that actually that's what the claimants are doing. They've just turned up to the court and played their chip, so to speak, and just hope that they get home, knowing that they've nothing to pay because they don't have the resources. But of course, enforcement of costs can lead to a number of things, of course, can't it? It could be a charging order, which, okay, they don't own their own property, so no charging order. But they're also at the risk of being made personally bankrupt if a defendant chooses to go down that route, and that can have significant implications in their life and their lifestyles going forward. So I'd stress that to them. Second risk that they face is, of course, contempt proceedings. If a judge finds a person fundamentally dishonest, a defendant could then apply to the High Court for contempt proceedings to be brought against the the claimant, and that would, I think, almost inevitably lead to some form of custodial sentence. The vast bulk of people who are subject to contempt proceedings do get sent down automatically. A small minority receive suspended prison sentence, but it is treated very seriously. Now, of course, the risk of that happening, maybe on the, a early October afternoon in a county court, may be quite remote. I understand that practically, but that is the risk, and they need to be appraised of that risk. Building on from that, of course, even if they have nothing, a defendant can get a costs award and register it as a county court judgment. And that county court judgment on paper can lead to credit problems going forward, again, impacting on their everyday lives. I think also trying to be practical about it, and I'm sure a number of our audience have already seen this, the stress and anxiety that a number of claimants face when they're giving evidence, particularly in these sorts of cases. If FD is run as an argument by the defendant, they're often in the witness box for significant periods of time, and some rise to the challenge. Others, I've got to say, just really are at sea with it and think that answers they give have got some element of plausibility to them when frankly they don't. So I think stress that, the real life experience and anxiety of having to give evidence isn't perhaps as it's perceived to be on, a soap opera or whatever. It is pretty rigorous cross-examination, and it's done politely, of course, because every court will ensure it's done politely. But it is quite systematic and often prolonged. Next point, I suppose, ultimately, it is down to the client. It's their decision. as to whether or not they proceed with this. You've got to point out all those issues to them and let them reflect as to whether or not they wish to continue. So what I'm going to suggest, if you've got proper concerns, bring these concerns as soon as possible to a claimant, so that they do have time to reflect. And I think sixthly and finally, because I know we want to represent our clients' best interests, have a look at your conditional fee agreement. Are the terms of that CFA, do they allow you to actually say cheerio to the client because of obvious areas of dishonesty that may be found? From my own personal perspective, I've had to use the CFA to say bye to a couple of clients because the terms of the CFA allowed me to do so, because the nature of the evidence that had been brought by the defendant gave me real causes for concern that what I was being told by the client was actually completely and utterly contrary to video evidence that was being brought before me. Now, it's often a tough route to go down, I accept that, and is going to be fact sensitive on the case and also term sensitive given the nature of the conditional fee agreement. And that might be, I understand it's the last point, but it's like a self-serving point, because clearly if someone's at risk of a real risk of FD, they may well not win the case at all, because fundamental dishonesty is found against them, either under 4416 of the CP or Section 57, where the sum award of damage is made for a legitimate claim that will be simply taken away from them. So I think, those are the only pointers I can sensibly make. A final point really is sitting. You do see any number of clients who literally convince themselves that they're telling the court the truth. They've got into this mindset, I'm going to call it delusional, of whereby they've, 180-degree pivot from what they've been actually saying hitherto to what they're actually saying at court. So it's a difficult one, but that's what you've got to try and do. And clearly you are acting in their best interests, and as I said, let them reflect. So I think that hopefully covers most of the points, Emma. Thank you.
Yeah, no, definitely. That was really thorough. And I think a couple of things resonated for me. One was that the stress of actually taking the stand, and that is not to be underestimated. But also, what you were just saying there about some people, you can call them delusional. They have an amazing ability to completely believe what they are about to say when you've got doubts as to, and particularly when there's contrary evidence. So and I'm sure there's quite a few times where it's grey, but you just have a feeling that something doesn't quite add up, as they say. Going on from that, actually, it was a related question, is do the courts ever consider awarding indemnity costs against defendants who run arguments of fundamental dishonesty and then aren't successful?
It is, because I've sort of been asked this question before. Technically, it is possible to get an indemnity costs award against a defendant who's run fundamental dishonesty and been unsuccessful. I've got to say it's rarely done in practice, but it can be done pursuant to the rules. And sitting, I've contemplated doing it once. When I'll just give you quickly the fact. It was a retired teacher. He was in the witness box for 2 hours, and it appeared to me, as I was the judge, he was just honest. He was just telling the truth. There were some inconsistencies about what he'd said, And actually, you felt for him a little because he'd been put through the proverbial ringer. I've talked about this rigorous, systematic cross-examination. And I thought to myself, well, there's not much in this. There's not much evidence to show that this guy has somehow gerrymandered the process and seeking to recover an award of damages that was way beyond what he was entitled to. It always was and remained a modest claim. There were some inconsistencies, and it was slightly, I think, inappropriate for that to happen. So that's an example where I'd thought about it. Ultimately, I didn't do that because there was there were some inconsistencies. And in fact, he got indemnity costs on his case, funnily enough, because he'd made a Part 36 offer. So he got what he was looking for in any event against the defendant, but by another route because he was more successful. The judgment I gave him was at least as advantageous as the offer that he'd made. But turning now generally to indemnity costs, and I think it's an important point for everyone to understand, is that indemnity costs are only appropriate where the conduct of the party is unreasonable to a high degree. And that's the key there, to a high degree. And unreasonable doesn't mean merely wrong or misguided in hindsight. And actually, that's what I thought the defendant had done in this case. They had been misguided in their approach, but really on reflection, they should have realised that. So how do you get to establishing that the conduct of a party is unreasonable to a high degree? And the answer is you've got to bring to the court some evidence to show that the nature in which the case has been conducted by the defendant or the circumstances of the case in general takes it out with the norm. It's outside the norm. So to give you an example, if you've got a couple of inconsistencies in medical reporting, a claimant reports, I recovered within 4 months, according to, my visits to the GP, or he or she says that in a witness statement. And then you look at the Part 35 medical experts and that's showing 6 to 8 months. Well, frankly, that's a pretty thin basis on which to say someone's fundamentally dishonest. Generally speaking, that isn't the case anyway. There's normally a two plus, often 4 or 5 points that are material that the defendant can say, well, look, this is questionable as to whether or not this is a genuine accident or a genuine injury. So it's got to be something out with the norm, this unreasonable conduct to a high degree. Pursuit of a weak issue on fundamental dishonesty on its own will rarely merit an indemnity costs award. So just pursuit of a weak assertion, rarely will you get an indemnity costs award. Pursuing a hopeless defence of fundamental dishonesty, or the defendant should have realised that it was hopeless, does lead to an indemnity costs award. How do you improve your prospects of getting indemnity costs in these cases? Evidence, please. That's what a court's looking at in relation to this matter. Bring some evidence to the fore to show that, in fact, this was a hopeless attempt at trying to establish fundamental dishonesty. The judge, of course, will be human enough, I'm venturing to suggest, within the bounds of their judicial oath, to see a lengthy cross-examination of an honest witness. And that's going to have some currency, but it's generally not enough to say, the claimant's been put through the ringer on this and it's never been going anywhere. That's not enough. To get home on this, what I'm going to suggest is, in an early answer, bring this to the fore earlier raise it in correspondence as soon as you're aware that the defendant may well be raising this. Get that challenge out there. If you persist in this approach of fundamental dishonesty, where it might be a spectre in some correspondence that's going to play out at a trial, get that raised and repeatedly raise it. Then you can bring, as it were, the correspondence trail to the judge at the conclusion of the case to say, look, judge, we've been mentioning this. We asked them to reflect, to consider their position on it, and it's gone unanswered. That, I'm going to suggest, it is now pushing the conclusion that actually this conduct is out with the norm, because you've put a couple of shots across the bows or even through the mainsails of the defendant to say, if you persist, this is what we are going to do. And despite those observations, they've carried on and done it. So in summary, therefore, rarely to get an indemnity costs award in favour of a claimant, but that's how it can be done. Thank you.
That's great. Thank you. Thank you, Andrew. And I'm very pleased to see Simon. Welcome, Simon. We've got you on the call. That's brilliant. Andrew's done very well holding the fort with fielding all the questions, and on that, actually, another delegate has raised the first question, which was, is it easier or more difficult to establish vicarious liability after the decisions in Barclays Bank and Morrison's? So that has been answered, and you will be able to view that when the video of this session is sent out. I'm not going to ask Andrew to answer that again, but the answer is more than fully responded to by Andrew already on this session. So welcome, Simon. Can we hear you? We can certainly see you. Oh, can you click on your microphone at the bottom left of the screen?
Can you hear me now?
Oh, we can hear you now. That's great. Yeah, we've got you. Okay, and so Simon, straight over to you. Andrew, you can have a little rest for a moment.
Have the mic off.
Turning to a question to you, Simon.
Yeah.
We've had some questions pre-submitted regarding expert evidence.
Yes.
So what steps do you take to ascertain if an expert is suitably skilled and qualified?
Well, that's a big issue at the moment, because lots of experts, of course, are putting their names forward to act as experts, and it doesn't mean that just because they're promoting themselves in directories as experts that they have sufficient experience and qualifications to act as an expert in court. So one needs to ascertain through the expert the amount of times they've appeared in court, how many times they've obviously been instructed to act as an expert for a claimant or defendant. Are they familiar with their obligations to the court under Rule 35? And actually, how are they able to assist the court on this specific issue? Sadly, we live in a climate where people put their names forward to act as experts, and by the time the solicitors instructed them and incurred costs, the solicitor suddenly realizes that they're not able to assist at all, because they come back with a negative opinion. And then when you have a telephone conference with the expert, you suddenly realize they're not an expert in your field anyway. So I think it's worthwhile, obviously, sifting through who the appropriate expert is and exploring all of that before you incur all the costs. I've come across that time and time again, where I've had conferences with solicitors and clients, and you start pressing the expert on issues, and actually they're not really in a position to offer an opinion because they don't have the depth or the background or the experience to do so. So I always do the research. I mean, some experts' names are well known, and we come across them all the time, and we know they're pretty good because they've appeared in cases, they've been reported, they have a particular speciality. But there's more to being an expert than saying, well, I've got a few years' experience behind me. So that's my experience.
Okay, thank you. Just on that sort of, well, on a similar point really, in terms of expert evidence, how do you determine if expert evidence is necessary and required?
Well, I think any question of fact is always going to be down to witnesses, and an expert will only be of assistance to the court if it's outside the knowledge of the parties and the judge. The judge can't act as an expert, but sometimes issues can be resolved by the judge and witnesses, and it doesn't necessarily follow you need to incur costs calling experts on every single issue to try and bolster your claim and try and sort of prove what you're trying to establish. So one is to stand back and say, well, what weight and what assistance is this expert going to add to what we already have? I mean,
yeah. It's a fundamental question, is it going to add anything to the proceedings?
Well, it will, because judges now are looking at proportionality and costs, and what's the purposes of this expert. I mean, we all know those cases we get where we need an expert on valuations, speed, standards of professionalism, etc. But sometimes there are experts thrown around just for the sake of it in order to try and bolster a particular claim. And I think judges now are a lot more sophisticated in ironing out the necessity to having an expert earlier on in proceedings, particularly where the issues have been addressed at case management.
Okay, great, thank you. We've had a delegate question. The employer is refusing to disclose risk assessments. Yeah. What can we do to obtain the documents?
Well, if it's pre-proceedings, then you make an application for pre-action disclosure. That's the only way you get disclosure from a party who's going to become party to proceedings. You send your pre-action letter and the protocols. If they don't comply and provide you with all necessary information, then you make your application to the court for a pre-action disclosure. And of course, they'll bear the costs of that. I mean, some employers tend not to engage solicitors, in my experience, one, because they may not have insurance, and two, they try and sort of become obstructive from the outset before they then have to engage. And of course, the problem with claimant solicitors, they don't want to go off and issue court proceedings without being able to ascertain whether they've got a good case or not, and whether the employer had any risk assessments in place in the first place. So my view is it always has to be a letter threatening pre-action disclosure and obtaining an order for that party to disclose specific documents.
Okay, thank you. There was a follow-on to that one as well. Oh yes, actually, picking up on a couple of points you mentioned there in your answer. How do you determine if the risk assessments are sufficient, and what happens if the employer has no insurance?
Well, take the latter point first. I've had quite a few where the employed does not have insurance, and you then have to weigh up the value of the claim and whether or not the company is going to be good to pay it. We've all had those cases where we sue employers and they haven't got any money and you can't enforce the judgment anyway. If they're partnerships, then you can go against any of the partnerships, any of the partners. They're all jointly liable. If it's a sole trader, it's about asset tracing that individual. If it's a company and there's only one director, then you'd attach the director personally to the proceedings on the grounds they're the driving force of the company and in control of it. So they should be the party responsible for the damages in any event. I mean, without insurance, sadly, those are your limits as to how you're going to achieve it. It's the first point of your question is a risk assessment sufficient? I mean, give you an example. If you're pursuing a claim because somebody's working at height in the workplace, I think most lawyers will be able to tell whether or not the risk assessments disclosed by the employer sufficiently provide training on working at heights and appropriate guidance of what the employee should and should not do. That's just a judgment call of the lawyer at that stage, and whether or not, I mean, the health and safety executive have lots of helpful guidance on their website as to what is appropriate in workplaces. There's lots of guidance booklets but we tend to be able to spot them straight away. The main issue with employees in the workplace is they are never shown these assessments. And some employees will say, actually, I never went through this process. The employer says, well, you're an employee and there's the handbook, but it doesn't mean the employee has read the handbook and has accepted all this material. So that becomes an issue also at court.
Yeah, okay, thank you. So question now to you, Andrew, back to you. If that's okay, we've had a live question from a attendee. What happens at trial if a client blames the solicitor for repeated inaccuracy in claims notification forms and or their own witness statement and or medical evidence when being challenged about the honesty of the claim that they're bringing?
Yes, it does occur a little more frequently than you actually want it to happen. But this is the answer is about waiving privilege. In essence, that's really what the question's looking to deal with. I've seen this probably 2 or 3 times when sitting. The judge's approach, if it's being at trial, is if somebody says, oh, well, the solicitor's made a mistake on the CNF, I think most judges would just leave it at that. That's what the witness says. It's a mistake made by the solicitor. The issue tends to arise where this is occurring repeatedly, where the answers made by the claimant in the witness box are one, it's the solicitor's fault, and I told them about this at the time and they've never corrected it. And so they start to develop and embellish an answer. And then if you've got to a particular stage, which is really down to the judge has got to say, to the barrister, basically, you do realise that there's a risk here that the claimant may be waiving privilege, and that can only be done really consciously, if that makes sense. So what I've done, because it's happened on a few occasions when I've been sitting, is I've stood the case down where this has been repeatedly said. At trial, it's the solicitor's fault. I've told them to correct it. They never did. They're a bucket of rubbish, or whatever terms they're using. And in one case, the claimant said, "My solicitor told me to say this." And I've been encouraged by the physiotherapist to bring this claim, and I tell my solicitor this. And that really did cross the threshold. So, number one, stand the case down. Number two, you give permission for the advocate, the barrister, to speak with their client, because remember, they're still giving evidence, and the barrister should not speak to the client whilst they're giving evidence. And I'm no doubt aware of that, but the judge gives permission for that conversation to take place, so they can have and then they come back. If they persist in this approach of solicitor blame, then regrettably you are going to have to, having reconstituted the court, order that privilege is waived in the file of papers that solicitor has, and give some further directions as to how this case is going to be conducted. And that could mean statements from the claimant as to what they're now saying, because it's rarely going to be, never in the witness statement, and also an opportunity for the solicitor to comment, maybe about attendance notes and the like. And you'd also have to reserve costs. Most of the time that this will occur, of course, is in a fast track regime, but of course it can be in the multi-track, and therefore you're really limited to a day's trial. But obviously the trial's gone off on one. because of what's arisen. So you reserve costs and then rearrange a fresh hearing when the file's been disclosed. No doubt the advocate will advise the client that they're going to have to take independent legal advice and the like. And so that will take a period of time for the information to be assimilated, and obviously disclosure of the client's file will go to the defendants, and they obviously want opportunity to pore over it with a view to cross-examining further and or seeking costs against the solicitors if they're somehow been negligent at best or at worst, guilty of conduct that they shouldn't be involved in, with obvious other consequences that arise from that. So as I say, that's really what should happen. In the case that I'm describing, one of them, where the claimant blamed her solicitor, when we did get the file at the reconstituted hearing, it was in very much apple pie order. There were clear warnings given to the claimant on the file about pursuing the claim and the risks of contempt and fundamental dishonesty and the like. I won't name the case or where it was, because frankly, I hope I don't sound too cynical, I had a little misgivings about the gold standard of perfection that the file documented, but it did seem very good, as it were. And the claimant, to be fair, she confirmed she sort of backtracked at the second part of the trial and said she'd probably misunderstood what she'd been told, and was a bit equivocal about it. But I mean, that's the mechanism. Namely, one, are they prepared to waive privilege consciously? And if they are, then all that sort of process and orders will be made thereafter. Thank you.
Yeah, thank you for that. I mean, it goes without saying that's not a situation you want to be in. And on that note, a question now for you, Simon. What do you do if your expert changes their mind?
What, during the evidence?
Yes.
Well, I mean, if it's your own expert, you can either treat the expert as a hostile expert and then cross-examine your own expert to determine why he's changed his mind. But you're better off if the expert, bearing in mind they would have been joint statements, and if he radically changes his mind in evidence which undermines your claim and therefore sadly leads to your claim being dismissed, then you'd have to bring a claim against your expert for negligence and damages, because that at that stage, I mean, judges, of course, allow experts some leeway, and having heard evidence, they might want to change their opinion slightly. But if they radically change their mind, then it's a negligence claim. There's nothing you can do about it, unfortunately. You tend to pick it up at joint statement stage, hopefully, and then you sort of read the right act to your expert without going to trial and having to pay the costs. But it does happen. Then sometimes, you could also, just picking up what Andrew said, I mean, if you're at trial before the judge and the expert has behaved in that way and it's not given the judge an explanation for changing his or her position, then you can apply for a waste of costs order against the expert for all the costs, because it very much depends upon the circumstances and how it arises.
I mean, just jumping in there to follow up on what Simon said, I think there has been a recently reported case where an expert in a clean neg case was ordered to pay just short of £89,000 in costs to the NHS Trust, and he'd gone in a witness box and didn't know the Boland-Bolitho test. Yeah. And that was on the backdrop of mental health issues that had prevented him from being in clinical practice. And I say more than a little surprisingly, he completely failed to disclose this to instructing solicitors. So,
yeah, I mean, experts can raise various issues. I was involved in that case, not at trial, but I was instructed. I was instructed to defend a firm of solicitors who were also attached to the proceedings for waste of costs. But that application beforehand was withdrawn. And then I brought a claim on behalf of the claimant and the solicitor for professional negligence, also against the expert. And that was issued in the High Court, and damages followed there. So it wasn't just the sum of money he had to pay to waste of costs, obviously, on the trust. He ended up paying a significant sum in damages for the solicitors who'd instructed him for a loss of opportunity of pursuing the claim. So it does get very expensive for experts. But also, just picking up what Andrew was saying, that's what I said originally. When you instruct experts, it should never have got to the stage. A barrister and solicitor should have checked that the expert knew the Boland test before even coming before a judge.
Absolutely.
You know, you do all these checks and pose all these questions to make sure you've covered your ground.
You've got to do your homework.
You have to do your homework, absolutely, because everything's about cost now. Everything's, it's a costly exercise.
It is, and actually, judging by the questions we're getting from delegates, this experts is clearly a troublesome area, because I've also been asked to ask you, what remedies do I have if I haven't done my homework? I've added that in, and the expert is deemed incompetent and unsuitable by the court. Yes,
well, that sadly, where a judge reaches a decision and prefers the expert evidence of your opponent and then gives reasons for that your expert is unsuitable and simply was not in a position to assist the court, gosh, it should never get to that stage. No, because, you know, the legal team who were working on it, you should be testing and probing your expert throughout. I mean, for a judge to pass judgment like that, gosh, your expert really must be poor and so bad. What more can I say? I mean, it should never reach that stage.
No,
I suppose the remedy is suing the expert, as
right.
Said, you know, Jones and Carney, isn't it, that allows that to occur. I mean, again, just jumping into, I had a case where one of the experts in the case was cross-examined about his GMC reprimand. So he'd been reprimanded by the GMC. And again, it was a case where the solicitors he'd been instructed by, he hadn't disclosed this to them. But the internet being the internet, a powerful tool of cross-examination, claimant's counsel picked up on this. And his answers did him no credit, frankly. He'd sent a message of a sexual nature via text to a vulnerable patient, and he basically brushed it off, saying, "Oh well, it was too much money to defend." None of it was true, but he'd been given a reprimand.
Could I just pick up on a point following on, just for the delegates online, that becomes important now. When you instruct an expert, you need to make sure he produces his indemnity provider for acting as an expert, because I've had situations where, just depending on what field they are in, that sometimes they are members of associations, and those associations that normally indemnify them for their general work in their specialism will not cover them to act as experts. And the expert has never appreciated that. So I would always say, when you instruct an expert, the solicitor should always ask for a certificate of indemnity at who's actually indemnifying the expert to act as an expert. Because if you've got a substantial claim, then you want to make sure there's appropriate indemnity cover for it, just as we are expected as barristers and solicitors to have appropriate indemnity.
Yeah, that's a really good point. Thank you. And actually, we're getting to time's up, so I'm going to wrap up now. Thank you both very much for answering those questions. That is unfortunately all we've got time for today. Thank you for attending Law 2020 online. Personal injury shape the debate. Once again, thank you to our expert speakers, Andrew McLoughlin and Simon Butler. Thank you both, you've been great. Don't forget to join the Solicitors Group Law 2020 online community on LinkedIn to continue the debate after this session and to be included in exclusive offers for next time. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within 48 hours. And there is still time to watch the pre-recorded content. The expiry date is displayed next to the webinar. Feedback forms for the event are sent out after the event closes, and by completing the feedback form, you will receive your CPD certificate. Don't forget to visit the online exhibition, www.thesolicitorsgroup.co.uk, and by visiting the exhibition, you can access a free 1-hour CPD webinar from the Distance Learning Catalogue. Thank you both once again, and enjoy the rest of your day.
Thank you.
Thank you very much. Thank you all.
Thanks.
Thank you.
Bye.
Take care.
Bye, Simon.
Bye.
Bye.